Welcome. My name is Wanda Rochelle, and I am a licensed realtor and probate specialist serving Georgia, Florida, and Alabama. Welcome to my channel. I am so excited today. We have a treat. I have a special guest with me today, attorney Nancy Wasdin. And today we are talking about things to not put in your will. And that is a hot topic. If you could go ahead and introduce yourself, Nancy.
Hello, I'm Nancy Wasdin. I am a practicing attorney. I do wills and probate, and I do real estate. My law firm is Wasdin Law, and I have a closing law firm as well. I've been practicing about 20 years and have done estate planning and probate throughout that, sort of sprinkled around. I wouldn't say I've seen everything, but I've seen plenty. Happy to be here today, Wanda.
Awesome. Thank you for joining me. And you are licensed in what state?
Georgia and Georgia only. So we'll be speaking just to Georgia. However, some of these things we'll be talking about, in my opinion, cross state lines and perhaps even countries, because we're speaking of things just as humans, what we may or may not want to encounter when someone passes.
Awesome. So let's go ahead and get started. Again, everyone, we're talking about things to not put in your will. And so what's one of the first things?
One of the first things is specific dollar amounts. I have some people that say, I want to leave X number of dollars to my grandchildren or to a certain charity or a school, some sort of gifting. And the problem is that if you have an estate that either doesn't have that value at the time we go to disperse it, or those assets are not liquid, the executor or whoever's handling the estate at the time is locked in to perhaps liquidate some assets or do some things that may not be advantageous to the estate itself or even for the beneficiaries. I would prefer to see percentages. I know that we don't always know how much money we're talking about, but if we have a general idea, usually people can manage with percentages a little bit better than specific dollar amounts. The other option is to do what we call in cash or in kind. So you could say, for example, $10,000 or something similar, or in cash or in kind is really the language. And what that means is if we have $10,000 cash, great. If we don't, maybe we have a piece of jewelry, a vehicle, some electronics, something that when we get them appraised equal that amount, so we don't have to liquidate to find that cash.
Okay, awesome. Awesome. I did not know that. I learned something new today. So what else should we not put in our will?
So I had on the list gifts of personal property. What
Mhm.
I mean by that is if you have specific gifts that you want to give someone, personal property means the items that you have around your house, and they can change hands, disappear, break. You can change your mind. You can give them away during life. So if we have a will that has a list of so and so gets the china, so and so gets the tea set, so and so gets the champagne flutes, um, and we can't find those things, or perhaps we have 3 sets of champagne flutes or 2 sets of china, it can cause misunderstanding. Now, what I prefer is the wills that I prepare have a paragraph that says, in layman's term, hey, executor, if you find a list with my will, please do what it says. And so you can have a list that you put with your will and you write down those documents and be as specific as you can, right? The tea set that I got on my trip in this year, or that sits in the dining room at Christmas time, or whatever it is. And then if those things change, or God forbid break or whatever, you can change out that list instead of having to update your will. And it just causes less confusion and, of course, less reasons for people to fight. If you have things in your will that are confusing, and this goes for everything we're talking about tonight, it causes potential for fighting. And we've gone through so much effort to make our will. We don't want people to fight over things, and we certainly don't want anyone to succeed in getting something that you didn't intend for them to get.
Awesome. So if there are personal items that I'm creating my will, it shouldn't be in the will. It should be a separate list.
I want you to talk to your attorney about it when you're preparing your will. What I
Mhm.
tell people is if we have something really specific we know people are going to fight about, we can put it in there. And then you have additional language where if it doesn't exist or if it's been given away or something, you add language after that, right? The tea set I got on my trip that sits in the dining room at Christmas time, if it is still around. If not, this gift shall lapse, and that's it. You want proper language in there. I do encourage people, I'll ask every now and then, do you have something in your possession that actually belongs to someone else or we think people might fight over? And I've had some answers to that. One was a tea set. One was a Japanese sword. I've had people holding money or a shared account with a sibling, all kinds of random stuff like that, or family photos. Those are highly sensitive items. And this is a time I will go ahead and throw in the comment, things do not have to be worth a lot of money for people to fight over them, right? I had a friend talk about the family fighting over the frog plates, and they were just the plates that the family used. They're not worth anything, but I fought for years in court over it. So just things to think about when it comes to personal property gifts.
So while we're talking about the personal property gifts, I want to ask this question because just this week I have a new probate client, and the executor reached out to me to go to the house just to view the home so that I can create a comparative analysis, a CMA. While I was there, the person that passed away has one daughter, and he never had any other children. So she was there, even though she doesn't live in the same state. And her mother was there, who is the ex-wife of the father who passed away. So she was ex-wife number one. So while they're showing me the house, there was a corner with a bunch of paintings. And she mentioned that the will had already stated that ex-wife number two was it's getting good. Ex-wife number two was supposed to get these paintings. And so she's telling me this because she doesn't live here either. She lives in another state as well. So her comment to me was that they had obviously no one could get any item, and this is my question. No one could get any of those items until the petition was filed with the courts. Can we talk about that?
That is an excellent point. What you're talking about is when somebody has the power to start handling the administration of the estate. So we're dealing with paintings, frog plates, china sets. At what point is someone permitted to take that item and give it to either someone that it says in the will specifically, or as part of what we call the residue of the estate, which is the everything else. And that is a particularly, legally speaking, there's one way, and practically speaking, there's another. So legally speaking, if you have a validly executed will that you can offer for probate that goes through the probate court, you will eventually get issued letters testamentary, they're called. That's a judge's order, and that is after the probate process. So it's not just when the petition is filed, it's when the actual petition has been considered by the court and then the powers are granted. So there is a time lapse there. Any of my fiduciaries, or personal representatives, that's sort of an umbrella term for anyone responsible for an estate or responsible for anything that's not theirs. So as the executor, you're now responsible for the estate of the deceased. So it's items that aren't yours. I go ahead and advise them too, even though they don't technically have the powers, you want to do what's called marshal the assets. You want to protect everything as much as possible. Keep paying the insurance, keep paying the utility bills, electricity, water, pay the mortgage if you can. You want to keep the assets in as best of shape as you can to hold the value to then be able to distribute the estate. So it's kind of a long-winded answer to your question, but if the paintings are sitting there in the room, technically no one is allowed to really do anything with them until those letters testamentary are issued, giving someone the power to go ahead and administer the estate.
Awesome. I wanted to make sure you clarify that because this particular case was awesome, and they did that. They knew that no one could get anything.
That's amazing. I'm surprised that one of the exes didn't take off with them. That's kind of where I thought that story was going.
Right. I have seen cases where everybody's just coming in getting, everything. So awesome.
It's stealing. People think they're entitled to it. It's stealing. It might be. Well,
wow. Yeah. That's another video, huh?
Yeah.
All right. What is the next thing that should
What's
not be
next on my
placed in the
list?
will?
My next one is gifts contingent on life events. What that means is I have clients come in and they say, I want to give everything to my kids, but they only get it if they go to college, if they get married, if they're still part of the church, if they have this kind of job, whatever it is. Those things have a myriad of potential of unintended consequences, right? If you want them to be in college, what kind of college? If you want them to earn a degree, what kind of degree? And we can specify that and say a 4-year degree from an accredited university and all that. But even then, what they mean is they want their children to thrive on their own and to meet these milestones. So
Mhm.
that's part of the counseling that I do. I try to shy away, especially things like getting married, having kids, all that. You don't want your beneficiaries running out and doing those things for the purpose of receiving your estate. The general idea is you want the kids to be independent. So we have more of a talk about holding things in trust for the beneficiaries, and that is for their benefit, right? Those funds are allowed for health, education, maintenance, and support. So we do all those things, pay for all those things as we need to, and then we're paying out at a certain age or that sort of thing, rather than specific life events. So that's what I mean by those sorts of things. And it usually is if you hold anything in trust for their benefit. And I certainly don't want it to only be paid at that time, because then what do we do if that never happens?
Right.
So, yeah, there's a lot to think about there. The idea of what they're trying to do is certainly able to be accomplished, but I prefer it not to be on certain life events.
Awesome. Awesome.
Mhm.
Again, I learned something new today. Love it.
You understand what people do that. They'll tell me like, "Oh, okay, let's pay out the trust at 18 so they can pay for college." And it's like, no, the trust is permitted to pay for college, post grad, starting a business, buying a house, a wedding, vacations, cars, any of those things that are part of health, education, maintenance, and support. But what you do is you nominate an adult, a trustee, to help the child budget and to approve their expenses. So when they say, I want a new Tesla, you can say, oh, let's talk about a Honda, right?
Wow. So just listening to you explain all of this really just stresses the fact that we should have an attorney do this for us.
So I am not a hater of online information. You can Google and find all manner of documents that are actually pretty good. But we've already talked about several examples of unintended consequences. When you say these things, I know what you mean, and I know to talk about some of these options. Let's have that extra document. Don't put the personal property stuff in the will. Let's talk about holding things for a trust. Don't make them get married, those sorts of things. So an attorney's advice is always going to be preferred when we're dealing with what language is in the will or in these documents in general. Not only that, the most important part of any estate plan is the execution, the signing ceremony, right? Georgia has a pretty high standard as far as how everything needs to be executed. We need 2 witnesses. We need a self-proving affidavit. The powers of attorney are certain ways as well. They're a little confusing the way they're written, so it's good to have guidance, especially with the living will portion, which is all the pull the plug stuff. So as much as advice on how to draft and what to put in the will, even if you get a hold of a good one and have good language, how you sign it and who's there and how all that works is so important. So yes, I always recommend hiring an attorney, talking to an attorney, getting counsel on how to do this, and any heartache and potential fees and all that you may save down the line will well outweigh whatever fee you'll pay to get the documents done.
Awesome. 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 Great information. If you're watching, be sure to share the video with others because this is definitely information that everybody needs. So share it with your family and your friends. Let's see, what is the next topic?
Oh, sensitive financial information. That dovetails a little bit with some of the DIY documents that you can find online. People often will come to me and they already have in their mind what their assets are today. And so they will say, I want my Fidelity account to go to this person. And I had a woman the other day with a soda pop stock, right, that you can't buy anymore or whatever. I want that to go to these people. And I want my other account over here that I've had forever and these stocks or CDs or whatever. And I don't want you I don't want you naming general or specific accounts in general, like we talked about. I would like to see something more general, but I definitely don't want you putting account numbers and things like that into your documents.
Mhm.
It's easy to think, oh, I need to put all this in there. I don't want your social security number in there. Things that banks may ask for, and you think, oh, well, they're dealing with my money, and so I need to give them as much information as possible. The probate process is public, meaning we're going to take the will, like we talked about, and submit it to the court and to end up hopefully with the letters testamentary. That is part of the public record of the court of that county.
Mhm.
So anyone can walk into the court and request copies of those documents. So I don't want that to be on there. So as much, not only sensitive financial information, but some of those specific gift type of things like we were talking about helps avoid that. And also, as people come to me with these specific gift ideas or thinking, oh, my Fidelity account, and oh, my stocks, that's today. And people's situations can change quite drastically. We have banks that go away overnight, and we have companies that merge. And I make that comment as well to gifting that they want to do. People will say, I want to give to this church. This is the church that I go to today, and that's what I want it to be. And it's not that that church may go away. It's just maybe it merges with something else. It changes names, or maybe they move, retire and move and join a different church. And so we like to make it a little more general by saying, the church to which I'm attending with regularity at the time that I pass, or a similar organization at the sole discretion of my executor. Meaning, if they're not going to church at that time or haven't been anywhere regularly, the executor knows what they meant. They meant to give a portion of their estate to an establishment related to that faith. And so they're able to go ahead and find that based on the language in the will.
Wow. Wow, that is good information. So let me ask this. If it's an account, wouldn't they have a beneficiary? So it would not even need to be in the will?
Well, that is an excellent question. And I did want to get to that a little bit because you were talking a little bit about exes getting paid and that sort of thing.
Mhm.
If we take away nothing from this video, and I know we're several minutes in, I want you to know, at least in Georgia, the accounts that you have, I call them open enrollment type accounts, 401ks, life insurance, IRAs, those things where they push that piece of paper at you when you open the account and they say, hey, if something happens to you, put down here where you want it to go. Those are beneficiary forms. Those are very powerful, and they very often, if not always, override what your will says.
Mhm.
And that is where people forget. They get divorced or a relationship changes, and they forget to update the beneficiary form. And what happens is those banks will write the check in that name, and that's it. There's just not a whole lot that can be done at that point. The reason being, the banks, the big financial institutions that have all this money on behalf of people, insurance companies, they don't want to get involved in the drama. They don't want to have to deal with the probate process. They don't want to have to talk to brothers and sisters calling in angry and everything else. They're like, look, I have this piece of paper. It's signed. It says where it goes. I sent the checks. My job is done. So
Right.
that's one of the things, homework, I call it with my clients. I say, listen, you've told me you have your Fidelity account and your soda pop stocks and these other things. Go ahead and check, call the bank. Each bank can be a little different. We all know they have their policies and they have good reasons for those. But I want you to call those financial institutions and ask them, hey, if something happens to me, what's on file? Where, what form do I fill out? How is it going to be handled? And then I usually give my clients what to say after that, depending on if they have a will or a trust or how we want to structure it. So it's very powerful. It's easy to forget. And it's just one of those things, if we remember nothing else from tonight, it doesn't have anything to do with what's in your will, honestly, but it is about what's not in there. Your beneficiary forms need to be updated. Also, please don't put minor children on there if you can help it. Minor children cannot cash checks that come from a life insurance policy. We need to do all kinds of things that it's possible to deal with. But what I find is when you're dealing with grief and loss, the last thing you want to do is have to deal with a lot of court stuff, go to court and have a conservatorship established and open a special type of account at the bank, have to provide accounting every year and all those things. Get an estate plan in place and get some sort of trust language where you can put the beneficiary toward a trust and not to minor children, and certainly not to an ex.
Awesome. Awesome. Good information. What is the next thing that should not be in the will?
I think you put it up there for me, which is great. I do not, in general, I do not permit my clients to name co-executors or co-fiduciaries of any type. There are a couple reasons for this. Number one is, what that means is, so for me, I have one adult child and a husband. And if I'm like, you know what, I want them to decide together on how all my stuff's going to go. Immediately you have an issue, because if one says no and one says yes, and they're unable to decide, unless you write in tiebreaker language, it's difficult to unwind that. It's difficult to figure out who's supposed to make that decision. And if you write in language, tiebreaker language, which essentially says, hey, if you can't agree on this for a week, a month, or whatever, then husband decides or son decides. You're ultimately choosing one of them over the other. So just go ahead and name them alone is my thought. The other thing is, and perhaps one of the biggest things, by and large, again, banks, they don't want to get involved in drama. They are essentially refusing to open accounts where they are looking for two signatures on a check, right? I'm dating myself a little bit, who writes checks anymore. But when you have two people that are authorized together and together only, and they have to authorize every single expenditure, the banks don't want to deal with that. So they're making people choose one person as well. So why don't you go ahead and make that decision? You can make them backups, right? Name this person, then that person. But I sit with my clients, and when they say, well, I want XYZ, I'm like, let's sit here and talk about who it is that you really trust to do this a little bit more than the other one, or who might be more available or whatever. And the other one will be a backup. The other thing I'll say about anyone that you name in your will, your trust, powers of attorney, anyone, they can always decline to serve. I have clients that say, I have to call my sister. I before we put her down, I have to make sure she's okay with it. And while from a practical standpoint, that's a great idea, be open and have discussions and everything, it's not required. If you name your sister and she can't or doesn't want to do it, she can always decline to serve. That's actually true of beneficiaries and heirs as well. If you're receiving property and you don't want the front plates, you can disclaim, it's called, and you can say, I don't want it. So anyone you name in your will, I guess, at all, can decline to receive or decline to serve in the roles that you nominate them for.
Awesome. Awesome. And I'm glad that you said that if they approach you wanting to name a co-executor, that you educate them on why they should not do that. So to me, that speaks to your character, because if they're doing that, they don't understand the consequences. And you could have just said, oh, you're paying me, let me just do what you asked me to do. So thank you for that.
Oh, thank you. I make the joke, they don't call us counselors for nothing, right? Everybody tells me their stories. I love it. We've all got it. People get embarrassed sometimes, like, oh, I've got a cousin in jail. Like, we've all got one of those. It just is all part of it. And I feel like when you have an experienced attorney that you're talking to about drafting these things, they can help guide you in the best way to handle those potential situations of unpleasantness.
Awesome. Awesome. So the next thing that should not be in the will.
Oh, we have another one. Oh, yeah. So I ask people about this in general because there are a myriad of issues that come up, mostly religious. When we're talking about funeral stuff and sometimes healthcare, there are some pretty hefty religious concerns that come in. Some don't permit blood transfusions. Some is cremated. Always cremated. Some are buried within a certain amount of time. I'm missing some, but I always have that discussion about, do you have anything important regarding your care or disposition of your remains? Now, what I don't want to see is the very specific. Some people have a plan, y'all, like, or songs and the kind of beer they want and the kind of cookies they like, all kinds of stuff. And I think that's great if you have ideas for that sort of thing. But again, that's today, right? These are the things that we think today. And you may have a different favorite song at the time that happens, right? Hopefully you're going to be around a long time and there will be a lot of songs that you could maybe have as your favorite. So I don't want anyone locked in their will saying that specific as far as funeral arrangements. I do want things that people should know, like things that aren't permitted health wise or religious issues as far as remains, if there's a time constraints on that or really specific requirements or wishes there. Yes, I do want to note that somewhere in there. The other problem is, though, that if it's in the will, a lot of times by the time we go looking for that document, the funeral and everything has already happened. So there is a spot to put it in the healthcare power of attorney. So that's usually where we talk about that. But I also don't let my clients get too specific with that. Some people have purchased, oh gosh, I've heard so many, like a mausoleum, like in New Orleans, you can't bury the people because it's below sea level. So they have all the, I think they're called mausoleums. And so she had a spot and like you pre-purchase those, her whole family is there. And I thought, well, what I want you to do is keep that paperwork with your documents I'm doing for you. So that's findable, reachable by everybody. And then also we're going to know, hey, I've purchased a mausoleum and as general as possible, but this is where I want to be. So yeah, I like to address it, but I don't want to be super specific. I do think it's a great conversation to have with your loved ones and something to think about yourself if you have opinions on it.
Awesome. Awesome. So the next one, let's see here. This is one of my favorites.
I love this. This is, what comes to mind? What is that song, the Taylor Swift song? What is it? The one where she's talking about her daughter-in-law kills her for the money. She thinks I left them in the will. The music video is kind of weird, but there's this interlude that is a scene. Have you seen it? Of the family reading the will, and it's all this dramatic thing. It's very Hollywood, right? I have had people request for me to do a will reading. I don't think I've ever really done one because it's for me in my practice and what I've encountered, it's not really a thing. Now, sometimes people, again, grief and emotion, and we need to get together and talk about it. Not a problem. We can have a meeting and talk about what this says and everything. The only person I really need to talk to is the executor, and then we'll deal with the other beneficiaries and heirs and that sort of thing. But that's kind of Hollywood stuff. But in general, if there are emotions involved where if you're disinheriting a child or someone close to you, or you leave them a dollar, I've heard some of these things, it's just not really appropriate, not the best place for it. It can cause issues like I talked about where people start suing each other and get angry. You don't want to dust up a bunch of drama at that time. It's not a great time for it. And again, it might change. What if something happens with that relationship right before you pass and now you have this nasty emotional, probably, that's a thing. And you kind of hope for that. If you have a strained relationship or something and you have sort of this nasty sort of off the cuff, I was angry one day and wanted to put all this in there, that just has potential for more damage in the future to future generations that may not be necessary at all. So air your dirty laundry somewhere else, people.
Yes, not in your will. Not in your will. Awesome. So I want to make sure that everyone has your contact information. Before we end, do you have any comments you want to make? Maybe something that we missed?
Let me think. Yeah. I say a lot of the same things when we start talking about wills and everything. We touched on a lot of them as far as keeping things in trust for kids. Age of majority is 18, but anymore, that's just so young. So I talk a lot to my clients about holding assets in trust for a while to let the kids grow up a little bit and be a little more responsible. As far as talking about trustees, I talked about no co-executors, right? But who I do want you to choose as an executor is the person that you trust to do that. People will start to say these comments, well, I want it to be my dad, but he's older than I am and he doesn't live here and English isn't his first language and he's not great with computers. I don't care about any of that. I want it to be the person that you trust today to do this for you. Now, all those other factors do exist. So that's why we name backup people. So if dad's the person that you trust with that and dad's not available to do it, let's talk about the next person down the list. And there is no limit to the number of backups that you can have. I usually see 2 or 3. The other question I get a lot is, where do I keep my originals? What do I do with the originals? For me, in my practice, when you sign everything with me, you leave with the only originals that exist. They are yours. You've paid for them. They're yours. What I tell people is to keep them in a fireproof, waterproof box, or maybe one of those bags, or generally with their important papers. We are increasingly a paperless society, but maybe there's some sort of box or file cabinet or a Rolodex. No, I'm kidding. I'm dating myself with all these references, but somewhere that someone would think to look for your documents if something happened to you.
Yeah.
I also send, a PDF copy to my clients. And so maybe they keep that in a folder on a desktop or something. I also tell people, let your loved ones know, hey, I've done this, and this is where they are if you ever need them. You can give a copy of your healthcare power of attorney to your primary care physician. You can give a copy of your financial power of attorney to your CPA or financial planner. They may also want to see a trust or a will or that sort of thing. And then, of course, my office keeps a copy, that PDF of what it looked like when it left my office. And I am findable forever. I'm listed with the Georgia Bar even after I die. So the worst comes to worst, they can try to contact my office.
Awesome. So I want to thank you for joining me today. I do have Nancy's contact information here on the screen. I will also have it in the description area of this video. So feel free to contact her for any of your estate planning needs. She is an awesome attorney. And I'll say this, I met her at a pro bono clinic that we have here in Georgia where they have free services. So I appreciate the fact that she takes time out of her schedule to offer free services to people once a month. Well, they do the clinic once a month, but I've met her. That's actually where I met her. And so I want to thank everyone for joining us today. I hope this video has blessed you. Things to not put in your will. My name is Wanda Rochelle, and I am a licensed realtor and probate specialist. I service Georgia, Florida, and Alabama. And if you're ever in need of my service as well, I will have my contact information in the video. Thank you for joining me, and thank you, Nancy.
Thank you.